You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 72. What is an ex parte Quayle action and how to respond to one? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or if it's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com. Or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of the state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. So in this episode, I'm going to talk about something that you might get from the patent office that looks like a rejection, but generally is a pretty good thing to get. And it's called an ex parte Quayle action. The name comes from a particular case called ex parte Quayle, so don't worry about the weird sounding name. The reason why it's good is that what the examiner has done is reviewed your patent application and found that the claims are allowable. So there are no more obviousness or novelty rejections. But before the examiner will actually formally allow the patent, some things need to be fixed up. Maybe there's some typo somewhere, or just something weird is going on with the drawings that need to be fixed up. I actually just got one recently for a design patent application. If you remember back to my design patent episode, where when you do the drawings, you have some solid lines and you could have some broken lines, and broken lines don't count as what you're claiming your design is, but it's helpful to see what the invention is about. And the one that I did, it was a blanket with a handle, and the design had nothing to do with the handle, so I didn't want to draw the handle in solid lines. So I drew it in broken lines that were all evenly spaced. Then the blanket had more than one piece that was stitched together, so I did the stitching in another kind of broken line that looked a little bit different because, I didn't care about the design of the stitching, so that's not what I was claiming, but I wanted to show that there was stitching that was putting these two blanket parts together. Now, I wrote in the description that broken lines were not part of the claimed invention, but the examiner didn't really like that and wanted it to be more detailed. The examiner already reviewed the design and found it was novel and non-obvious. So the hard part was done, but he wanted me to describe the differences between the broken lines, such as some were evenly spaced and some were made by a dash and a dot. So I just responded like any other amendments or and remarks, and following all the rules of amendments using strike-throughs and underlines, and described exactly what the different lines were for. That one was a type for a handle, and that the other type was for stitching. And then I submitted the response to the ex parte Quayle action, and a couple weeks later, I got a notice of allowance. Now, sometimes if it's a simple typo, the examiner might call you up and ask if he could do an examiner's amendment, and the examiner can do it themselves. But in other situations like the one I just did, it might be a little bit challenging for the examiner to try to come up with the exact wording used to describe the different kinds of broken lines in a design application. So they just send you an ex parte Quayle action. Once you get the ex parte Quayle action, you have 2 months to respond with no fees, and another 4 months after that to respond if you want to pay extra fees per month. So a total possible of 6 months. I guess it's always possible that you get an ex parte Quayle action, and whatever the thing is that the examiner says needs to be fixed up, it can't for some reason, and then you might be in a little bit of trouble. But I've never experienced that. It's usually something pretty minor that's not a big deal, and after you do it, the patent application gets a notice of allowance pretty quickly. And that's about it for ex parte Quayle actions. If you want help with your patent application, trademarks, responding to rejections, appeals, or anything related to your invention, you can contact me through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or call me at 424-281-0162. And you can also email me at adam@diamondpatentlaw.com. And I'm Adam Diamond. And until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.